Let's bring in a guy who knows a lot more about this than I do. Arthur Aidala is a criminal defense attorney in New York. He's seen about as many gun crimes as any human being has ever seen. There's a radio show called the Aidala Power Hour on 970 AM in New York City. All right, am I wrong, or did I make any mistakes in this?
Well, you didn't make a mistake by saying this is a very emotional issue. You played Governor Hochul's press conference. The mayor of the city of New York already had a press conference, although he crafted it a little better in terms of from a law enforcement point of view. He said, with the police commissioner at his side, this puts police officers at risk, because the more guns that are out on the street, the more likely that a police officer is going to confront someone who is either very heated, agitated in a domestic violence circumstance, who may take out a weapon that they normally wouldn't take, because it may be a law-abiding citizen, typically, who's now in a very intense situation and they fire a weapon. But let's talk about the
well, let me stop you there. That law-abiding citizen, if they have a permit to carry, has already gone through the system. They just can't take it outside.
Well,
right?
They couldn't take it outside, but today's ruling now says they can take it outside.
Okay, but what difference does it make? If you're in a domestic situation, you already have a gun in the house, do you not? If you're clean.
So you could also be in a domestic situation outside of a Broadway theater, which I happened to see last night. Walking home, I saw a husband and I presume screaming at each other. Look, let's just talk about the law, Bill. I'll stick to the law. You stick to the ramifications of the law. The person who's smiling down from above is Justice Scalia. Anyone who knows me a little bit knows I had an excellent relationship with him. And the decision of which he was the proudest was the Heller decision, which is the decision that now Justice Thomas, who was maybe Justice Scalia's closest friend on the bench, he wrote this decision, the Bruin decision, and they're relying on Heller because the Heller decision interprets the 27 words in the Second Amendment as saying, Scalia said, I'm not buying this whole, you can only have a weapon if you're part of a militia. And he parsed every one of those 27 words and what they meant at the time of the writing of the Bill of Rights. And he said, it means that you could bear arms, means you could carry a weapon. And Scalia limited to inside your home. And now Thomas took it to outside the home. And although you play that clip with Hochul saying, you can't scream fire in a movie theater, the Justice Thomas ends the decision saying you don't have to go to the government to ask for your First Amendment rights to be used or for your Sixth Amendment rights to confront witnesses against you. You shouldn't have to go to the government for the Second Amendment. The Second Amendment is not a second-class right. That's the ending of the whole.
Let's walk through this methodically. All right. So all this ruling from the Supreme Court does is give people in New York, California, there are other states, Maryland, Massachusetts,
New Jersey,
Rhode Island. All it does is if you can get a concealed carry permit, not easy, which is why Hochul lied. So I know now we're not going to have any Second Amendment restraints. BS. Not easy to get that. But
Bill,
the state had, wait. The state has to give it to you if you submit paperwork that say, I need this, all right, because of this. It's a reasonable request. If somebody comes in and they have a domestic battery on their sheet, counselor, they're not going to get the right to carry in any state, and you know it.
That is correct. That's when Hochul said she's going to call a special session to put that in. But I think if Arthur Aidala just walks in today, I wasn't able to say yesterday, look, I'm a defense attorney. I piss a lot of people off. I do a radio show. I piss people off there. I leave my office at midnight. I'm afraid I want a gun. I would have definitely 100% been denied. According to this ruling, I should not now be denied. You shouldn't be denied.
You shouldn't be. It's insane to deny someone like you in the public eye who makes enemies the right to protect himself. That's insane.
Well,
Don't you
see that? The Supreme Court just agreed with you. The Supreme Court just agreed with you. But let me play devil's advocate and talk a little bit about Justice Breyer's dissent. Justice Breyer, who's been on the court a very long time, this is one of his last decisions, and dissents are very important. He said in Justice Thomas's 63-page decision, he never says the word subway once. There are certain unique circumstances, and parts of Manhattan are one of those where, and even Justice Thomas says there should be special zones where you shouldn't be able to carry a weapon. I believe Thomas cites inside school buildings and inside government buildings and places of worship.
Public safety, absolutely. But look, my contention on this firearm stuff is very simple because I'm a simple man. You've known me for many years. Law-abiding Americans have a constitutional right to protect themselves with a firearm, period. And governments, state, local, federal, they have a right to impose laws that protect the public safety, but not when they know that the criminal element does not go through the system to arm itself. They go outside. So what all these lefties would do would ban you and me and every other law-abiding American from carrying a pistol, but would allow all the criminals to have firearms. That makes sense to you, Counselor?
Well, it makes sense to me, and I think this is on sound legal ground based on precedent of the Supreme Court, which we could talk a second now about Roe v. Wade, because now they're throwing precedent out. But based on the precedent of the Heller decision written by Scalia and the McDonald decision, this follows the normal course. Stepping outside the law as a New Yorker, what I'm afraid of, Bill, is the law-abiding citizen who has some sort of an altercation and takes out that weapon to shoot A and winds up shooting C and D. I believe the statistic.
Look, all right, that's fine, and that'll happen. But what about the citizen who protects his own life and his family when, do you know how many violent crimes are committed in New York State last year? Do you know how many?
I do not.
37,000 violent crimes. 37,000.
Out of 21 million people. That's out of 21 million people.
That's more than 100 violent crimes a day in New York State. Okay?
I understand.
So what about the person who saves himself and his family from violence? Okay? You can make the argument there might be and there will be, all right, some horrible thing from this concealed carry overturn. But
I will tell you this,
negated by the protective aspect. I want to get to Roe v. Wade. And people, and
wait, just one thing, Bill. I had the day before yesterday, I had the chief of the Detective Endowment Association on my show, and then yesterday I had a retired detective on my show. I will tell you, they're not thrilled with everyone walking around with guns, and even the law-abiding citizens walking around with guns.
They're entitled to their opinion. I'm not thrilled. There are 37,000 violent crimes in my state every year. I'm not thrilled, and I know the police are reactive, not proactive, Counselor, and so do you, because that's how you make your living. Okay, Roe v. Wade. So my prediction, back to the states, I think you agree with me there, right?
Yeah, because they created a right that didn't exist with Roe v. Wade. It didn't exist.
Okay, so the liberal judges don't care about creating a right that didn't exist, just like they don't care about, the Second Amendment that says Americans have the right to bear arms. Bear arms, that means hold arms. It's not a bear in the forest. All right, so is this ruling going to upset you, Arthur Idalia, the Roe v. Wade?
The reason why the ruling doesn't upset me is because, unlike today's gun ruling, Congress cannot go in now and pass a law and say everyone can't hold a gun, but because that's a violation of the Constitution. But what Congress has a very simple solution. They could just go in and pass a law that says every woman has a right to abortion. You can have a right to abortion. They can pass a law that says you have a right to abortion until the 9 months and 3 weeks.
They can do that.
But Congress doesn't have the guts to do that. So
they could do that, but
so
it would
now
be
it's going to go to the
overturned.
states to figure it out.
It would be overturned. Because
no, not necessarily.
Yeah, by the 10th Amendment, the Supreme Court would overturn it. If it's not specifically stated in the Constitution, as you well know, it goes to the 10th Amendment where the states make the law. That's what would happen if Congress passed it. So you'd be on the same
congressional laws. There are a lot of congressional laws that apply to all 50 states that are not subject to the 10th.
Doesn't make any difference. I think they haven't been challenged, and they hadn't reached this level. When it reaches this level, that's the law that applies. But look, in our state, New York, okay, if a woman wants to have an abortion at any time, You're going to be able to have it, Arthur. And if you live in Alabama or Louisiana and you come to New York, I think the legislature will put aside money to pay for your abortion in this state. That's what will happen, right?
That's what federalism is all about. I mean, the states are, that's where the Supreme Court of the United States is going to be a little criticized with the gun decision, because typically the conservative bloc likes to give as much power to the states as possible. And here with the Second Amendment, they've taken a state right away. And then tomorrow or on Monday, when they make their next decision about the Roe v. Wade, they're going to give the states the power to make their own decision.
But it's all based upon what's written in the Constitution or not written. It's ideology shouldn't be in here.
That's very key.
Yeah. Ideology shouldn't be a part of it. It shouldn't be a part of it.
What Justice Scalia used to say regarding the Roe v. Wade decision is the United States Constitution is not Prego spaghetti sauce, where they used to say, it's in there, garlic, it's in there, oregano, it's in there. Everything isn't in the Constitution. Certain things are supposed to be legislated. And he always said, if you want abortion to be legal in all 50 states, ask Congress to do it. Don't ask 9 lawyers who don't hang out with the public, don't know what people aren't in the bars, don't know what the community wants. We just read the Constitution and we interpret it the way we were taught in law school and through our experience. Congress's role is to pass laws that the people want. It's not the Supreme Court's role.
But it's also Congress's role to obey what the Constitution states. And if the Constitution doesn't state it, a la abortion, it goes back to the states, because that's what the founders put in there. Last word.
Last word is the United States Supreme Court is under a microscope. You know, you said about Chief Justice Roberts. I know him enough to know that he cares about the reputation and the integrity of the court as much as anyone ever has. And he must be going crazy. The fact that, number one, that decision was leaked by Justice Alito. I've been in touch with Justice Alito. It's sad in America that he now has all this 24-hour protection. I don't even want to talk about his family because I know all of them. They're all now surrounded with security. That we've come to this based on a lawyer, Justice Alito, interpreting the Constitution in the way it probably should have been interpreted 50 some odd years ago. Well, and now his life and his family's life are in danger.
Okay. Thank you, counsel. We'll have you back soon. We appreciate the debate.